Morning and welcome to the Vermont Legislature's House Committee on Environment and Energy. This morning, we have our Legislative Counsel, Michael O'Grady, to walk us through H-158, an act relating to the beverage container redemption system. Welcome, Michael.
Morning, this is Michael O'Grady with Legislative Counsel. Before I start walking through the bill, I want to reference a couple of documents that I've asked to be posted on the committee's website for reference for you. The Agency of Natural Resources has a pretty good website which explains the bottle bill and the various components of the bottle bill, including how the money moves, how the deposit moves, and what commingling is. So, and then there's additional resources there. I won't walk through any of those web pages, but if you want to, get a greater context for what the existing bottle bill does, that's a great resource. So I'll now start with the bill.
Representative Sebelius has a question.
Actually, a question for you now.
Yes.
So I have reviewed this bill and taken a lot of notes. Do you want us to go through and hear the whole bill?
I think that
rather than doing questions as we're going through.
I think so. Yeah.
Okay, great.
What?
Sure, just walk through and then, okay.
And where did you post that, the information, not the bill itself?
I
don't
think Kate posted it under my name on today.
I'm just seeing the bill is introduced.
Refresh,
Was it?
refresh.
Okay.
Okay, so I'll start. Generally, the bottle bill is currently an extended producer responsibility program where the manufacturers are required to pick up redeemed containers from the retailers and the redemption centers that redeem them. In that process, there's a movement of money between the manufacturers, the retailers, and the consumer. And there's two ways that money moves. I think most people are familiar with the deposit, the 5-cent deposit on most covered beverage containers. And that is paid to the manufacturer. Basically what happens is, well, I'm not going to go through it. Matt's going to go through it this afternoon, but basically that's the 5-cent deposit and how it moves through the system between the manufacturer, the retailer, and the consumer, and then back is one way that the money moves. The other way that the money moves is that manufacturers pay retailers and redemption centers a fee for each container that the retailer and the redemption center redeems. So that's the two ways that the money moves. Most people know about the 5-cent deposit, and most people don't know about the handling fee. Now, what this bill...
Yeah, I think this is very fundamental to our understanding. And if you would repeat that, and I think this, I'm going to give everyone try to pay attention. If you hear it again, that's great later from Matt. You're going to have to hear it more than once because it's the nuance is really important, and it's fundamental to understanding.
All right, let's maybe go to the how the money moves chart. It's not loading for some reason. Yeah, the link is broken, I think.
It's the same one on Matt Chapman's if you want to go to that.
I hit refresh and it got mine.
Here it is. It's under Matt Chapman's name. So this is how the money flows under the bottle bill. First, you have the product sale, and that deposit initiator is usually the beverage manufacturer, the distributor. They charge the retailer that's buying the product from them the 5-cent deposit. And they may charge the handling fee to the retailer as well. The retailer charges the customer the 5-cent deposit for the container. And then the customer pays the 5-cent deposit when they buy the beverage container. All right, now the customer has the can, which is also 5 cents. All right, so then they bring the container back. The consumer brings it back to the retailer. The retailer gives the consumer 5 cents. And then the retailer gives that container to the manufacturer, and the manufacturer gives the retailer 5 cents plus a handling fee. And the handling fee depends on whether or not the container is in a commingled program or is not commingled. Currently, if it's commingled, they get 3.5 cents. If it is not commingled, they get 4 cents. That's the current handling fee.
There is, I'm sorry.
Go ahead, Representative.
There are current handling fees on most deposit and refundable cans or bottles now.
There's a handling fee on every covered beverage container.
Thank you.
That was great. Are there other kind of questions on the basics here?
All right, so what this bill will do is it does several things. First, the definition of beverage container has always been kind of a mystery. Really, it's the definition of beverage because some drinks are in, some drinks are out. Now, nobody's really sure why any versus why some are out and some are not. And so what this bill is going to do is going to move away from defining the beverages by type, mixed wine drink, beer, soda water, and instead define the definition of beverage by what it is actually used for, and that is, it is all drinks in liquid form and intended for human consumption, except those products that have traditionally been accepted because of various nutritional reasons. One is milk, other dairy products, plant-based beverages, infant formula, meal replacement drinks, and then non-alcoholic cider. Most of those are there because of their nutritional value, the need for milk for children, or plant-based beverages as for those children who can't drink milk, the need for meal replacement drinks for people that need it as medicine, the need for infant formula. And then non-alcoholic cider was added last year in a kind of back and forth debate between you all. So that is the first thing that this bill does.
Representative Smith.
Thank you. Orange juice, tomato juice.
Well, that is what this bill is going to do. It is going to expand the scope of beverages to all beverages for liquid. It's going to include bottled water. It's going to include juices. It's going to include iced tea, which is currently not covered. It's going to include non-carbonated sports drinks like Gatorade, which is currently not covered. It's going to include everything that's intended in liquid form for human consumption.
Wouldn't orange juice and tomato juice be included in a milk not the milk family, but in something that someone, where they can't drink a bottle of milk in the morning, they'll drink an orange juice instead?
I mean, that's a policy decision. If you and as a committee or as a body want to add other drinks to the exception because of their nutritional value, I think that's a policy
Okay.
decision.
Thank you.
Okay. Yeah.
Thank
Go ahead.
you. I could be wrong, but I would also think there's a little bit of ambiguity with the term plant-based beverage and like orange juice, for example.
So isn't that defined later?
Yes.
So let's
Okay,
get to
that's
the
helpful,
walkthrough
thank
because
you.
it's 12 past and
Right.
it's 25-page bill. So
You did say no questions in the little.
let's, no, I wanted the basics answered.
A change that accompanies the expansion of the definition of beverage is the change in the definition of container. Because right now there are no size limits on containers because the nature of the products themselves are basically size limited. You don't get a 4-liter bottle of seltzer, but you could get a 4-liter bottle of juice. So what the definition of container does is it sets limits on the size by whether or not they're carbonated or non-carbonated. So you'll see on page 3 that non-carbonated beverages with a volume greater than 2.5 liters and carbonated beverage containers with a volume greater than 3 liters are not covered. So if the soda water is in a 3.5 liter bottle, it is not covered. Also, what's not covered are pouches, you know, the little drink pouches that kids have. They're not technically, they're getting to a point where they're almost recyclable. They're not technically recyclable in Vermont yet, so they are accepted. And materials made of containers made of biodegradable material are also accepted. So large containers, pouches, and biodegradable containers are not part of the bottle bill. Then there was a definition of plant-based beverage that was added. And I definitely had to come up with this myself last year, using Oregon and a couple of other resources. The liquid intended for human consumption that imitates dairy milk consists of plant material suspended in water, and the primary protein source in the beverage is from plant material or derivative plant materials. It includes beverages made from rice, soy, nuts, oats, and hemp. Floor last year, you were like, why isn't coconut added or referenced? You could reference coconut if you wanted to, but it was not included in the definition last year. Also included are cider and ready-to-drink spirit beverages. So I think everybody knows what cider is, but in this definition, it means hard cider. Non-alcoholic cider is not covered. Hard cider is. And then there's a definition of vinous beverages. That is wine and all its derivatives. Wine will be included. Wine will not be included until 2026. (2027), actually. I'm sorry. So that's the definition section, and it's a key part of this bill, the expansion of the bottle bill to all beverages for liquid consumption except those that I've specified are exempt, or those containers that I've specified are exempt. That's the first key component of the bill, expansion of the scope of the bottle bill. The second key component is going to be on page 1-5. And that is the beverage container deposit. You'll see that the existing deposit on page 5, line 5, does not change. It remains 5 cents. There is an opportunity later in the bill for a recommendation for that to change based on recycling rates, but currently the deposit is not changing. What is changing is on page 6, is that, or actually still on page 5 at the bottom of page 5, is that the handling fee, not the deposit, what the manufacturer pays the retailer for redemption would change, but only for those brands that are not part of a commingling program. So currently, the manufacturer distributor pays a 4 cent per container to the retailer redemption center for handling. That is going up to 5 for all those containers that are not in a commingling program. That's the second major part of the bill. Just a quick question.
That's Representative Moore.
Thanks, Michael. The reason for increasing the handling fee for the non-commingled?
Because it takes more sorts in order for the redemption center to separate the brands so that they can then be picked up by the manufacturer. When it's in a commingled program, which is most of the major beverage manufacturers and most of the major beer manufacturers, the redemption center can put them all generally in 1 or 2 containers and doesn't have to make as many sorts in order for them to be separated. But when you're not in a commingled program, they actually have to separate that non-commingled container out from all the others and put it separately from the commingled containers. And that takes time and more sorts. And they want to discourage people from not being in a commingled program. Moving on from there, you've got the 2 major components: expansion of the scope, the increased handling fee. There's a deletion of the rulemaking, but that's just being moved to later in the bill. We have provisions about acceptance of beverage containers. And generally, a redemption center and a retailer can't refuse to pay a deposit and can't refuse to accept for redemption those products, those containers that they sell. What is being proposed on page 7 is that a retailer may refuse to redeem beverage containers if a stewardship plan that meets the requirements of section 1532 of this title has been implemented by a producer responsibility organization and the retailer's building is less than 5,000 square feet. Now, you've heard a lot of those terms in the past week or so regarding extended producer responsibility for household hazardous products. This bill does a very similar thing for beverage containers. It requires manufacturers or distributors of beverages in covered containers to set up an extended producer responsibility program that follows the basics of EPR. You have a producer responsibility organization that registers with the state and all the brands that's covered under that organization. They have to submit a stewardship plan that provides for the collection of those containers, and that has convenience, education, funding, and payment components in it. And then it has to implement that plan and start to collect all those beverage containers at a certain time. So basically, you get the general EPR program built onto the existing producer responsibility program for beverage containers. Because remember, the bottle bill is an EPR bill as it exists today. You're just changing it from its current EPR status into a more extensive EPR program.
So say those again. We get convenience, education.
Sure, I'll walk through the components of the plan.
Okay, but just for the frame. So, you said with the EPR, we're going to get convenience, education, and
Convenience, education, participation rates that become a component of the required plan. You get payment of cost, collection cost. Those are basically the key components.
geographic. Isn't that
Pardon me?
geographic?
Right.
That's part
And-
of convenience.
Right, and that's built into the convenience requirement, and you'll see that, and I'll talk about that a little bit. Before we get to the components of the plan, there's an additional kind of not as important, a little bit minor. When you have a covered container, you have to label your container with the deposit information. And so it has to say this container is 5 cent redeemable in Vermont. And the law allows the label to include every state that has a deposit. So you'll see a Coke can says 10 cent, Michigan, 5 cent, Vermont, California, Hawaii, etc. For a metal container, that information is supposed to be on the top of the container. But there are now metal bottles where the container is this big or smaller, and it's hard to put all of that information, that required information, on top of a metal bottle. So what the bill does, it is allow for another approved method, approved by A&R, to put that information on the container so that it's clearly visible to the consumer. So it's not taking away the label requirement, it just allows the manufacturer to put it somewhere else approved by A&R on the container. Okay. The other part of the bill, to make the bill, or make redemption potentially easier, is that beginning in 2025, every product has to have a barcode and UPC code so that it's scannable and identifiable by manufacturer or brand. Okay, then you get to the EPR requirements. Distributor or manufacturer has to register 30 days in advance of initiating sale of the beverage container and participating in a stewardship plan. You don't get to sell in the state until you register 30 days before and identify that you're in a stewardship plan. I'm going to skip over that. And then no manufacturer or distributor may sell or distribute a beverage container in the state without participating in a secretary-approved producer responsibility program organization on or before January 1, 2024. Manufacturers representing 51% of the beverage containers sold or distributed within the state. So this is a way to limit the number of producer responsibility organizations. And this kind of requirement already exists in Vermont law for whether or not you can have a commingling agreement. So it's really not that substantial of a change in Vermont, except last year you said that A&R can approve additional commingling agreements if there aren't 51% of the represented manufacturers, because you were having issues with some of the smaller craft breweries who didn't want to participate in the larger commingling agreement. And so you gave A&R the ability to approve smaller commingling agreements. You might want to think about that here, but the concept with the 51% is to limit the number of producer responsibility organizations. You may have a similar dynamic that you had with the craft brewers. You don't want to get caught up in the larger organization.
So, I mean, basically this is saying we'll have one.
Pardon?
You would just have one.
Right. You'd have one. So that's what this is designed to do.
How many do we have now?
The commingling agreements, there's one major commingling agreement. I don't know if the craft brewers actually started their own after that was approved, but there's one major commingling. So once a producer responsibility is approved, A&R can approve that for up to 10 years. It has to show it has the capacity to administer the program. It cannot create unreasonable barriers to participation. After approval, they have to maintain that website that lists the contact information, lists every beverage or brand that's covered. And if they fail to implement the requirements of the chapter, the secretary may form or require the formation of a producer responsibility organization or adopt the state's own plan. If the secretary has to adopt its own plan, the secretary charges the cost of the plan administration to the manufacturers, plus a 10% administration fee. And then the PRO is required to reimburse the agency for all oversight costs in administering the chapter. And then you get to the minimum plan requirements. So on or before October 1, 2024, the approved producer responsibility organization submits its plan, it has to have convenience of collection. And it has to ensure that consumers have convenient opportunities to redeem beverages. It has to take effort to site points of collection in areas with high population density or in designated downtown centers and other designated areas. It will document how consumers will have at least 3 points of redemption per county that provide an immediate return on deposit. It has to have at least 1 point of redemption per municipality with a population of 7,000 persons or more. And that's kind of like St. Johnsbury and above. And then it has to have a statewide coverage of points of redemption so that consumers are not required to drive more than 15 minutes unless a waiver is granted by the secretary. So 3 points in every county, 1 point in every municipality with 7,000 persons or more. And regardless of those two requirements, a person should not have to drive more than 15 minutes to get to a redemption, place of redemption. There has to be a compensation component in it for compensating the redemption centers. And it'll describe how all locations that redeem beverage containers are fairly compensated for their participation. That could be more than the handling fee. Because when you talk to the redemption centers, you'll probably hear that the handling fee doesn't always cover their cost. And so part of this plan may include another compensation source for the redemption centers. Plan shall describe how management and sorting of containers is minimized, so to eliminate the non-commingled issue. It'll describe how materials will be picked up from redemption centers on a timely basis. That has been a problem. There have been, especially with smaller stores and restaurants, some delay in having their containers picked up for redemption by the existing contractor that implements the commingled agreement. It shall maximize the use of existing infrastructure when establishing points of collection. It will address the impacts to municipal recycling. Many of your municipalities run transfer stations, collection themselves, and they then sell what they've collected on the commodities market and make some revenue from that. If you're going to have a PRO that's doing all this collection and then selling from there, you're taking away a revenue source from the municipalities. So this plan has to look at how to fairly compensate the municipalities for that lost revenue. There has to be education to consumers. The plan shall describe what education efforts will be undertaken to increase the number of beverage containers redeemed in the state. They have to consult with stakeholders on the development of the plan. The plan shall include processes for regular consultation. And that's the components, those are the components of the plan. Just going back to the beginning for the components, you got convenience. You have fair operation and compensation to redemption centers. You have impacts to municipal recycling, effectively a compensation formula for the lost commodity revenue, education of consumers, and consultation with stakeholders.
Representative Pat, we're trying to hold questions, but if it's basic, that'd be great.
This is regarding the drive time definition. That is drive time to a redemption center that accepts all eligible containers, as opposed to a local store that only that isn't selling all of those products.
Sure. So it has to be point where there's immediate return of deposit to a consumer.
All
For all, yeah.
Okay. I'm just saying 15 minutes isn't going to cut it in Washington County.
That was part of a discussion that was had last year about whether or not there is a component of that 15-minute requirement that allows the secretary to waive the collection within 15 minutes. You're probably going to have some of that for more rural parts of the state.
Okay, I'm just saying in
So
terms of,
we just need to,
excuse me?
we got to get through the bill right now. That's,
Sorry.
thank you.
There's a reporting requirement. The manufacturers frequency required by the secretary, but no less than annually have to report. They have to report the name of the redemption centers that are participating, the amount of containers and tons that are redeemed under the plan, the location and amount of beverage container material that was recycled, the carbon impacts associated with the administration of the plan, the cost associated with the administration of the plan, including the cost of collection, management, and transportation of redeemed containers, and the amount received for commodities. They need to have a description of any improvements made in the reporting year and an increased ease and convenience. They need to report efforts taken by or on behalf of the distributor to reduce environmental impacts through the product life cycle, the environmental improvements for the container, and then they have to report on the environmental outcomes of the program by improving operational efficiency, such as truck trips and improved material handling or compaction. They have to provide their educational materials, and they have to provide any additional information required by the secretary. A&R approves, and they have to approve based on each of the elements, the major elements of the plan. There's a program audit every 5 years. A program audit looks at how well the program is actually working. And then there's a financial audit every year. Both of those audits have to be done by an independent third-party auditor. I think in the beginning, the fiscal audit annually is going to be important because of the costs and how those costs are allocated and the equity for the redemption centers and for the municipalities, and for how much it's going to cost manufacturers and distributors to do this. This is probably going to cost more than what they're doing now. But in time, I think you can move that fiscal audit to a 5-year audit once the program is in place. But in the beginning, I do think an annual fiscal audit is likely necessary for both the manufacturers, redemption centers, and municipalities. Now, earlier I had said that the deposit isn't changing, and it is not, but there is a redemption rate goal, and it's the goal of the state that the following minimum beverage container redemption rate shall be satisfied. So by 2026, you want 75% of containers recycled. By July 1, 2030, you want 80% redeemed. By July 1, 2035, you want 85%. And then by July 1, 2050, 90%. And then beginning July 1, 2025, and every 5 years thereafter, A&R submits to you, the General Assembly, a recommendation about whether the beverage container deposit should be increased to improve redemption of beverage containers. So the concept is maybe the state doesn't reach its 75% rate in 2026, and therefore A&R recommends to you that the deposit be increased to provide greater incentive to the consumer to redeem the container. It's not an automatic escalator. You've seen versions of this bill in the past that would automatically escalate the deposit based on failure to meet the redemption rate. It is not an automatic escalator. As you know, the Ways and Means Committee likes to control fees. This is a fee. They have approved or reviewed the deposit in the past, and likely do so again. Then you get to rulemaking. It's just moving the existing rulemaking authority to the end of the chapter to incorporate the EPR components. Then you get to it's really just technical movement of the money. So the concept, does everyone know what the abandoned beverage container deposits are? When you don't take your container that has a deposit back to the retailer, the manufacturer still has that 5 cents. Remember how the money moved? The money moved by the retailer giving the manufacturer 5 cents. Unless that container comes back to the manufacturer holds on to that 5 cents. That's how it used to be for a long, long time. Till a few years ago, you required the manufacturers to start giving back those unredeemed deposits. And
To the retailer.
no, to the state. Because the retailer made whole, but the one person that wasn't made whole was the consumer. The consumer was the one that never brought the container back and never got the 5 cents back. When the consumer paid for the container from the retailer got the 5 cents. The consumer is the one that never gets their 5 cents back. And so what the state said is that we're going to take those unredeemed deposits and use them for state purposes and not for the purposes of the manufacturer. Now, what this bill says is in the first few years of this program, because of the cost of the manufacturers and distributors to stand it up, they get to keep 50% of the unredeemed deposits. Now, what that means is you've got to take 50% of the deposits away from its existing use, which is the Clean Water Fund. And so these sections are about doing that. Section 2 lets the manufacturer keep 50%. And that takes effect July 2026. And then the next section, section 3, this takes away the retailer's ability to keep 50%. And so it goes back to 100% going to the Clean Water Fund under section 3.
In the manufacturers.
Right, to the manufacturer, sorry. And that takes effect July 2031. So the manufacturer gets to keep 50% of the unredeemed deposits for 5 years. And then it goes back to the Clean Water Fund somewhat.
Just an aside that's important when people are thinking about this, there will be more beverages covered. So likely, well, Clean Water Fund could remain. We don't know. We need a fiscal note on that impact.
Right.
So just so people are, yeah.
Right, because the scope of
Going that
the
way.
containers redeemed will be increasing. The scope of what is unredeemed will be increasing. So the revenue from the unredeemed deposits, the abandoned deposits, honestly, I don't know what it would be. I don't know if it'll change or go up, but it's probably not going to go down. Section 4 is about the notice that A&R has to go through when they're going to approve the stewardship plan. A&R has 5 different types of notice procedures. This is one that requires them to file notice of the plan on the environmental notice bulletin, give people public comment opportunity. It's really kind of a basic component of all A&R programs to build in what their notice requirements are. So then you get to the Clean Water Fund in section 5. You'll see that this is not effective until July of 2031. Now, I said earlier that you're going back to giving the revenue to the fund. Well, you're only going to give back 50% to the fund. After 2031, that 50% that the manufacturers have been using, it now goes into the solid waste management assistance account under section 6. And that is for use by it has multiple uses. One of the uses that it has is for use by municipal solid waste management entities for their costs. This was a debate about the use of the abandoned container deposits when it was moved to the Clean Water Fund. The SWMI said that money should be going to them because it's a solid waste cost. And so basically what is being proposed, and instead of taking all the money out of the Clean Water Fund, you're giving 50% of that revenue source to the Solid Waste Management Assistance Fund. Then there has to be a systems analysis of the beverage container system under section 7 to see how well it is doing, including its systems cost. And then there's a study of what the container scope should be and whether or not there should be further minimum and maximum size limits on containers, whether or not there should be some beverages that are not subject to the deposit, and whether and how to include wine. Wine as part of this program beginning in 2027, but you're going to hear from interested parties that wine bottles are a difficult to redeem, difficult to manage. And this study is about how best to do that. And then the effective dates, because many of these things are happening at different times, the effective dates section is long. The expansion of the beverage types occurs on January 1, 2026, except that wine is 27. The requirement for product registration is March 1, 2025. The requirement for UPCs or barcodes is March 1, 2025. The prohibition on sale or distribution unless you're part of a producer responsibility is March 1, 2025. The movement of the abandoned beverage containers, the manufacturer keeping 50%, that's January 1, 2026. The repeal of that is July 1, 2031. And the amounts going into the Clean Water Fund is July of 2031. And then the money going into the Solid Waste Management Assistance Fund is July of 20.
Thank you. That was very helpful. I have a question that, committee, I'd like to do 10 minutes of questions and then take a break before we start other testimony on this bill. I'm going to just ask a couple. Michael, how similar is this to the Senate passed version of the bill we sent them last session, biennium?
It's very similar. It's not exactly the same. There are components of the plan that were changed. There were some revisions around the containers. But otherwise, I would say it's about 85 to 90% the same.
Thank you. Representative Smith.
Thank you. Back to what you were talking about. Well, 15 minutes is neither here nor there. I think that can be overcome. But the redemption centers are going to be taking on. We've got a recycling center in Derby where they've got these bags that will hold probably 1,000 gallons of plastic, or they're huge bags. They're held open with stakes, and they have to throw plastic bottles into them. All these bottles probably will be going to the redemption centers now. And the main redemption center that we have in Derby probably is not going to be able to accommodate all of these. What's the town going to do in a case like that? Is the redemption center going to have to spend money to build an addition to accommodate this ruling?
So the requirement for collection and redemption and convenience is no longer on the municipalities, and it's not on the private redemption centers either. It's going to be on the manufacturer or the distributor. So they're the ones that are going to have to provide that point of collection. I will note that it does say that they're supposed to use existing infrastructure to the extent that they can. But if they can't provide for the collection and the convenience of the collection with existing infrastructure, they're going to have to set up their other collection sites or opportunities, and they have to pay for it.
That could be quite costly to small businesses, couldn't it?
Not the manufacturer and the distributors are the ones that pay.
Okay, so if you've got manufacturers and distributors of 50 different plastic bottle products, that means all 50 of these manufacturers are going to have to get together and form a little club to build a center to accommodate. Am I correct?
Yes, that's basically what happens with
Okay.
producer club. I like that. And figure out how to pay for it, figure out how to meet the requirements and figure out how to pay for it.
Okay,
Representative Sibilia.
thank you.
Yes. Michael, page 9, looking at penalties been repealed. Got the beverage registration there. My question is about enforcement.
Sure. So it's a good question because enforcement is not transparent in this bill because A&R already enforces the beverage container redemption system. And A&R has a chapter in Title 10 that lists all of the things that it enforces. So it's just going to continue to enforce this chapter. It doesn't, you don't need to, its existing enforcement authority remains, which includes cease and desist orders, includes administrative penalties, it includes ticketing offenses, it includes potentially significant fines. It has all that authority. It's a good quick. It's not transparent in the bill because it's built into the framework of A&R enforcement.
Okay. And along those same lines, so I'm just wondering how, and there's several places in the bill. So we've got the Department of Liquor Control engaging here as well. And then the PRO. So like, is it, can you explain kind of who's in charge of what? And are those the only 3 entities? It feels like they are the 3 kind of responsible entities.
Well, the Department of Liquor and Lottery basically already runs a product stewardship program because they collect all the redeemed liquor bottles and they get to keep all of the unredeemed deposits on liquor bottles already. They already basically run that program. That's going to continue because they are the manufacturer and distributor for liquor. They're the distributor. They don't make it.
Yeah.
They distribute it.
Manufacturer through me.
So they're the distributor so they're the one that has to have a PRO and they're going to have to be part of the program. Now, I think a question for A&R is going to be, are you going to require the other manufacturers and distributors to accept liquor containers? As it's drafted right now, I would say yes, but that's a question for A&R, I think.
So we have 2. Let's say,
You've got
see if I've
Liquor and lottery that are going to continue to run.
liquor bottles, and we've got the existing bottle bill. So bottle bill is A&R. Liquor bills are DLC. And we're gonna expand this. Don't let me go off the path.
If you, when you say A and R, that you're saying that they have the administration and enforcement
Yeah.
authority? Yes.
For bottles,
For everything under the current bottle bill. Except liquor,
which is over here,
which is here.
and then we're gonna expand,
You're gonna expand this,
which is bottles.
which is all the beverage containers, the bottle bill. You're gonna expand the bottle bill to include more beverages.
Yeah.
And more requirements for manufacturers and distributors. And right now, liquor is not expanded. It's not changed. The question is, will this have to accept the liquor bottles?
Yes, that's exactly my question to you. So
I believe the way that this bill is drafted right now, yes.
we're smushing the two things together, which will probably,
Well, they collect them now,
They do collect,
already in the system.
wait.
but they're
Who's
sorted.
that? And what is that?
They're sorted.
Centers collect them now, and that gets.
Redemption Center sorts them and they're taken out and sorted separately from the commingled program. And then DLL runs their program to collect them.
DLC. No DLL, you're right. Yeah, of course you're right. Never question.
I have a question and then I'll go to Representative Pat. I guess I read this and then I think about, in particular, the wine bottles. Is there a possibility or an option, or if a group of beverage manufacturers got together and said, we're going to stand up a reuse so that their bottles were not needed, they didn't have to recycle them. They could actually collect them and refill them and redistribute them. I don't think it's in here now, but is it possible to put it in here? Because wine bottles are so uniform. And it seems like an obvious place to start a reuse program.
I do think that there's opportunity for that. I honestly, I think it will be whether or not the product stewardship organization thinks it's the most financially beneficial thing to do for them. Because if you're having 51% in, you're probably bringing some wine people into that PRO, and then it's about what's the most financially beneficial thing for them. Is it to have wine separate, containers separated out so that they can be reused, or other containers as well? You've heard testimony in the past about how beer bottles can be reused, and that's one of the benefits of the bottle bill.
Okay, so those programs that are getting bottles just reused already go through this kind of thing. It's just they get collected and that's where they get sent to a reuse.
Right. I think it'll be about what the PRO thinks is the most financially beneficial use of the material. You know, aluminum's always going to be great for recycling. You don't reuse that, and it's always had a market. Mixed glass is almost the opposite, because mixed glass means it's been broken and contaminated. But then glass containers that are separate, they probably will have another market. They will probably have a reuse market. And it will be up to whomever is running that PRO to figure out how to do that the best way.
Representative Pat.
Yeah, I'm just going to go back. I'm sorry, I was a little premature with my comment, but it seems to me that 15-minute people being within 15-minute drive of a redemption center is completely unrealistic. I live closer to the main road in Worcester than a significant number of people who would be further away. I'm not 15 minutes from once there is a redemption center in Montpelier again, which would now be required. But I'm thinking of Middlesex, Worcester, Calais, Marshfield, Plainfield. Large numbers of people in those towns would be nowhere near 15 minutes. It would be much more than 15 minutes. Some people would be. It just seems like an unrealistic provision or then to have to write exemptions for parts of the towns where people are 20 or 25 minutes away, and other people are 15 or 10 minutes away. It just,
Or
it
they're
doesn't
gonna
seem
have,
workable.
or they're gonna have to put another collection site in order to provide more services.
Just the intent. I think with that, we're going to take our 5-minute break. And thank you, Legislative Council. That was, Avram, we're going to take a break.
Yes.
That was very helpful, high level, and we will get back into the details. Thank you, Michael. Take a 5-minute break and reconvene a couple minutes past 10.